does anybody want to volunteer to read those 3 pages? I mean, you said, I insist that you.
Which 3 pages are we doing?
Or maybe it was the 3 different
3 different
parts of.
on the back.
Oh, yeah, this is,
There's all kinds of instructions. Okay, I think this is. Yeah.
when we just read them, what do you think?
Yeah, it'd be
No, I
faster
think
just to
that's-
read the whole thing.
otherwise, If we all read, it's going to take
Okay,
forever.
instruction, duties of the judge and jury, instructions as a whole. It's his duty to tell us what the law is, our duty to accept or apply the law. You must consider all of the instructions together because no instruction includes all the applicable law. And so I give you, in order which I give these instructions is not important, your duty is to decide all the fact questions. Do not be influenced by any personal likes or dislikes, sympathy, bias, prejudice, or emotions. And burden of proof, preponderance of evidence. Whenever a party must prove something, they must do so by a preponderance of evidence. Preponderance of evidence is evidence that is more convincing than opposing evidence. Preponderance of evidence does not depend on the number of witnesses testifying on one side or the other. Evidence. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by deposition, exhibits received in court, stipulations, which are agreements between attorneys, any other matter admitted, answers to interrogatories, matters which judicial notice was taken.
I'm sorry, I hate to do this, but they're having some trouble with the audio. So can you
That's
hold
okay,
off
'cause
for?
we're-
Can
Do
we
you know
just-
which ones we were supposed to?
We're talking
We're just gonna
Is
read
that okay
the,
if we-
we're gonna
talking
read the
about our
instructions.
instructions, so it's not.
Didn't he
that
say
big a
there's
deal.
only like 3?
Yeah,
three
there's-
categories?
There's 3 categories. Yeah, there's
Preliminary, and then what is evidence, what isn't evidence, and then the burdens of proof and.
Yeah.
Okay, he
Well,
didn't really
it's
tell
not-
us what these are, he just left them.
Okay. Anyway, we talked about evidence.
Will you come back and tell us when you can hear?
Evidence may be direct or circumstantial. The weight to be given any evidence is for you to decide. Sometimes during a trial, references are made to pretrial statements and reports, witness depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during the deliberations. Documents or items read from or referred to which were not offered or received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and rulings on the objections, any testimony I told you to disregard, any you saw or heard about this case outside the courtroom, credibility of witnesses. You will decide the facts from the evidence. Consider evidence by using your observation, common sense, and experience. You must try to reconcile any conflicts in the evidence, but if you cannot, you will accept the evidence you find more believable. In determining the facts, you have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many facts you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, the witness' appearance, conduct, age, intelligence, memory, and knowledge of the facts, and the witness' interest in their trial, the motive, candor, bias, or prejudice. Corporate party. The fact that a plaintiff or defendant is a corporation should not affect your decision. All persons are equal before the law, and corporations, whether large or small, are entitled to the same fair and conscientious consideration as by any other person. Fault. In these instructions, I will be using the term fault. Fault means one or more acts or omissions toward the person, of the actor, or of another's, which constitutes negligence. Negligence. In these instructions, I will use the word negligence. I mean the failure to do something which a reasonably careful person would do, or the doing of something which a reasonably careful person would not do, under circumstances similar to those shown by the evidence. The law does not say how a reasonably careful person would act under these circumstances. That's for you to decide. Comparative fault. Damages may be the fault of one or more person. In comparing fault, you should consider all of the surrounding circumstances as shown by the evidence, together with the conduct of the plaintiff defendant and the extent of casual relationships between their conduct and the damages claimed. You should then determine what percentage of any each person's fault contributed to the damage. Causation. The conduct of a party is the cause. The conduct of a party is the cause of damages when it is a substantial factor in producing damage and when the damage would not have happened except for the conduct. Substantial means the party's conduct has such an effect in producing damage as to lead a reasonable person to regard it as cause. Negligent entrustment. An owner of a motor vehicle may be liable to an injured person on the grounds of negligent entrustment of its operation to an inexperienced or incompetent driver. Iowa law requires proof of the following elements before a plaintiff may recover for negligent entrustment of a motor vehicle. The owner entrusted its vehicle to another person. That person was unlicensed, incompetent, or reckless. The owner should have known that the person to whom it entrusted the vehicle was unlicensed, incompetent, or reckless. The driver was negligent on the occasion in question, and the driver's negligence caused injury. Compared to fault. Single plaintiff, essentials for recovery. The plaintiff claims the defendant was at fault in one or more of the following particulars. The defendant's employees were operating the truck in a negligent manner, specifically in one or more of the following way. Defendant's employee operated the truck so it was facing south, but defendant's employee was operating the truck in reverse at a high rate of speed. This is the part I think is important. Defendant's employees also failed to keep proper lookout. Defendant's employees failed to yield right of way to the vehicle being driven by Mr. Little. The defendant negligently entrusted the operation of his truck to Mr. Miller. In order to prove this claim, the plaintiff must prove all of the following propositions. The defendant was at fault. In order to prove fault, the plaintiff must prove defendant's employee operated the truck so that it was facing south, but defendant's employee was operating the truck in reverse at a high rate of speed. Defendant's employees also failed to keep a proper lookout. Defendant employees failed to yield the right of way to the vehicle being driven by Mr. Little, or defendants negligently entrusted the operation of his truck to Mr. Miller. The defendant's fault was a cause of the plaintiff's damage. If the plaintiff has failed to prove any of these propositions, the plaintiff is not entitled to damages. If the plaintiff has proved all the propositions, you will consider defense comparative fault as explained in Instructions 12. Comparative fault, single defendant, essentials for defense. Defense claims the plaintiff was at fault in one or more of the following particulars. The plaintiff was operating his motor vehicle in a negligent manner, specifically in one or more of the following ways. Plaintiff operated the vehicle at a high rate of speed. Plaintiff operated the vehicle without using headlights. Plaintiff operated the vehicle while failing to maintain a proper outlook. Plaintiff operated the vehicle and failing to reasonably apply brakes. And plaintiff operated the vehicle while under the influence of one or more substances, including alcohol and/or marijuana. In order to prove the claim, the defendant must prove both of the following proposition. The plaintiff was at fault. In order to prove fault, the defendant must prove the plaintiff was acting negligently by doing one or more of the following. Operating the vehicle at a high rate of speed, operating a vehicle without using headlights, operating a vehicle while failing to maintain a proper lookout, operating a vehicle and failing to reasonably apply brakes, or operating a vehicle while under the influence of one or more substances, including alcohol and/or marijuana. The plaintiff's fault was the cause of the plaintiff's damage. If the defendant has failed to prove either of these propositions, the defendant has not proved its defense. If the defendant has proved both of its propositions, you will assign a percentage of fault against the plaintiff and include the plaintiff's fault in the total percentage you found by answering the special verdicts. Basically, it boils down to the fact that we have to determine if the plaintiff proved that if the plaintiff proved that the defendant operated the truck so it was facing south, but it was facing south, but the defendant's employee was operating the truck at a high reverse speed. The defendant employees failed to keep proper lookout. Defendant's employees failed to yield the right-of-way to Mr. Little, and the defendant negligently entrusted the operation of his truck to Mr. Miller.
Okay.
And then the defense has to prove that the plaintiff operated the vehicle at a high rate of speed, operated the vehicle without using headlights, plaintiff operated the vehicle while failing to maintain a proper lookout, plaintiff operated the vehicle and failed to reasonably apply brakes, and the plaintiff operated the vehicle while under the influence of one or more substances, including alcohol or marijuana. And
So, let's,
it doesn't say we have to prove all of them. It says that the defendant claims the plaintiff was at fault in one or more of those areas. And the same for the other way around. It's one or more of those areas.
And it's percentage.
Could be a percentage. It could be all one way. It depends how you decide.
okay, we're just gonna go around. Tom, you start, we'll go.
Sure.
over.
I feel like, like they said, there's a lot of debris that you got to kind of clear out of the way. You got to read between a lot of the stuff. I feel like there's a lot of responsibility on both parts. Like they both contributed to this. I feel like Andy was probably, on something. He obviously had been drinking. If he'd been pulled over, he wasn't legally drunk. So I feel like Dana probably has more of the responsibility and is more guilty because I feel like a lot of the evidence proved that he was erratic. Some of the testimony and stuff, it just felt like he was trying to hide something. Some of the evidence was inconsistent with his past and everything, the text messages. I feel like he was probably pretty erratic, and they should have seen the headlights because it was proven he had his headlights on, just as much as Andy should have seen the truck. I think Andy was distracted. I think Dana was being erratic. I think when he pulled out, they just didn't see each other. But I feel like Dana had more responsibility being, his position. He should have had more adequate safety protocol, and I think that was what resulted in the accident.
I feel the exact opposite. I think that the utility company is not at fault because, first of all, when you take and look at the police report, it said he had a blood alcohol level of 0.7. But if you look at the police report on the screen and not listen to what they're saying, it says the sample was contaminated.
Yeah.
So that means he could have been 0.23%. There's nothing to say that he wasn't.
I feel like there was a lot of
He was
evidence
impaired.
left out also.
Yeah, he was impaired, there's no doubt about that.
The other thing, what was it? I believe that the fact that the officer said that the utility company was at fault is totally doesn't enter into the picture because he got cited, but he hasn't been proven guilty. And so, he hasn't gone to court, so you can't count what he said. The other thing, when I look at all these diagrams of where what is, I've probably done 40 diagrams. I think the part that gets me is first, I believe the defense's mechanical engineer more. I have an engineering background. I didn't believe the plaintiff's expert witness as well as I believe the defendants. He was more together. Somebody testifying is not going to say it was precisely 52 miles an hour. He's going to say, well, it was between here and there, because you're recreating something. You can't set a point on it. You just can't. And the thing that got me the most is that when you look at the things on those things they kept referring to about Mr. Miller and all that kind of stuff, about what it says, that he got
The reports.
freaky and all that stuff. Well, when you look at what his supervisor said is, if there are any warning signs, he should go to be evaluated. There was nothing presented about any warning signs, so I assume there were none. And so if he went to a psychiatrist or psychologist or whoever, he went on his own. And that has no bearing on anything, because what's private between a person and their doctor is just that, private. And he wasn't sent by the company to the doctor. He went on his own.
He was recommended to go.
But
No.
the supervisor
No.
recommended.
No,
Yeah.
his supervisor did
Well, we
not
got the evidence
recommend
here,
him
don't we?
till the second time. Till after the second thing, the one here, after the accident, then the supervisor recommended that he gets counseling. The first time, there was, it just said
Do
if
we
there
have
were
that
any.
evidence?
Because I thought in the
2013.
the second time it
supervisor
wasn't
said.
the driver that they were recommending, it was the.
Yeah, it was still,
the
Damage to
drinker.
company's
it was
the
Mr.
first
Miller,
time.
no. It was
Recommend
both
that he
times.
be
2013.
evaluated
Yeah, here,
if he
let's
shows
see.
other warning
Here's the-
signs.
It says right here
Deposition.
in the
Is that the
supervisor's
2013?
supervisor notes. This is the 2013 sign down here.
Okay, I recommend that he be evaluated if any other warning signs appear. There were no warning signs. So they didn't recommend him to anybody.
At that time, I
Wow.
feel left that up to his discretion.
So,
Yeah, well, you can't imagine. You have to go by what the evidence is. The evidence is that they did not present anything that there were any warning signs. So we have to presume there weren't any, or the plaintiff would have put them on the table.
Yeah, they're giving him a pass on the first one, waiting for the second.
so let's go with percentages then. Tom, between Andy and Dana, you tended to feel
That Dana was more
if you were going to give it a
responsible.
60, 40, 30, 70, what percent do you think Dana would just give a rough
I would say
idea?
a 40-60.
40, 60, so he's 60%. Okay. Chris, if you're going to just throw a percent out there, if it's 100%, fine, but just give me
It's
a percent.
100%
100% on Andy.
on Andy.
Okay. Okay. And
Pick a number.
Oh, God.
Talk it through.
Yeah,
I mean,
Right.
like the other people did.
Yeah. I mean, obviously Andy was impaired, and I feel like if he was going down that service road and he saw a white truck right there, I mean, he should have at least went into the left lane to avoid the truck. Or, I mean, put on his brakes, but I mean, that's also an option I would have taken if I were him. So, I mean, he had to have been so much, he just had to have been so impaired that he couldn't make, I don't know, he couldn't make
Judgment.
a judgment, yeah, basically. And so I feel like Andy is at fault.
100%.
I would say 100%.
Okay. Okay.
Percentage-wise, I lean more towards the Big A driver being the more at fault. He did fail to yield. A lot of what happened before that doesn't matter. It's at the moment they collided what they were doing that
That's what I was
matters.
looking at.
So he could have backed all the way to Sunday. It doesn't matter. It's when you're actually involved in the incident that matters. And obviously they were not, they should have both seen each other. I agree with that. I mean, there's no reason, they're both at fault. But I think the bigger share goes to the truck driver because he had more than one person, should have been looking, and he should have seen the headlights way before he even started backing out.
Yeah, I feel like they backed out real quick.
I have a question though.
But I think he was scared.
You remember when the lady at the end had that cardboard
Yeah.
truck that you put up on the picture? When she had it go, at one point it showed the truck going forwards. He'd been He came up, okay, he backed up that quarter of a mile, he backed into that driveway. But when he came out, he was going forwards. So he would have pulled in here forward, and Andy would have hit his back end,
Yeah, that's what bothers me is the closure part. Yeah.
you know?
I think there was a lot of misinformation
Yeah.
in her testimony.
very
I mean, there was a lot of things that she said that I kind of felt was contradicting other evidence and stuff, and I kind of,
You have to remember, she's the attorney and it was a
I know.
closing. It's
I know,
just,
but-
it was just the cardboard truck that made me think, because I hadn't thought about the fact that maybe they backed up and backed into that road, so that would make them pulling out. That's the only thing that I
They
saw.
all said
took
they
it.
were backing.
You
But they
think he
had-
pulled out and turned,
I think,
and then Andy struck him, or did he back out and then was going forward?
I think he might have
He backed
backed
out,
that
yeah.
quarter of a mile. Let's say, I mean, I don't know. I'm saying, if he backed this quarter of a mile to the cemetery road, then he backed into the cemetery road. That means his front of the truck is this way. So when he pulls out to go south, his front is going south and the back end is here, and that's what Andy hit.
But
And I think-
Dana,
I think
Dana
that's-
actually
Because any other-
said, Dana testified that when I backed out. He
Yes.
didn't say I pulled
Yeah.
out.
So
He
they-
said,
Well,
I
that's,
backed
that's
out.
fine. It was just that, I just had that question because of that cardboard truck that attorney had.
Okay, so, Gay, as you said,
I'm
100% on Dana?
No.
Failed to yield?
I'd go
Maybe-
with 60-40 or 70-30.
Okay. Okay.
All right, so I'm leaning toward Dana being at fault because he went north on a southbound road, first of all. His outlook didn't notice, he and his outlook didn't notice someone coming. But there are some other things that really bother me, and perhaps these aren't relative, but they are to my thinking. If you're in a crash that has that kind of an impact, how does a beer can end up upright outside of the crash site? How would a beer bottle still be intact between the person's legs? Why is the marijuana in such a noticeable area and yet has no fingerprints on it? So I feel like there was some cover-up, and I also feel like Big A was trying to blame both Mr. Little by making him look suicidal, Lisa by trying to be money hungry, and John Ward by disparaging him. And why would you do that unless there was a reason? So those things really bothered me.
now also, the car, they cut that open like with the jaws of life or something. I mean, to get it to be like that. I mean, I'm sure it was an awful, awful accident. It looks a lot worse being torn open like that also. So there's all these little things that, they keep saying, this was horrific. Look at the destruction of this vehicle. Well, some of that's aftermath stuff. So like even that beer can, I mean, I can't imagine that it just flew out of the car and landed right up.
Why couldn't it? It could do that
It very well
just
could
as
have, but I
much
don't
as it-
believe that
as
because the car was all closed up to begin with.
Yeah.
I mean, you
it
didn't.
can
It
fly.
had a roof on it. at
You
one
didn't
point,
know that the window wasn't open.
right? But problematically, I feel
It had just as much probability to do that as to not
Right.
to do that.
I just,
So
but
doesn't
how does the can of beer fall out and not the marijuana that's been sitting on the front seat?
right, and the beer in his lap.
Right.
I mean, the car went so far under that truck, you would have thought that would have shattered. Or
Well,
I
I'm
mean,
with her. I think the bottle of beer was broken. I think that's just
No, I
something
don't
that
think
was
that-
stuck in there to
Oh, I think that was-
confuse matters. To somebody said
I
there was a
agree.
bottle of beer. There
I
was
think
no.
they
Never
put
said
that
it
in
was
there.
broken, though.
No, they didn't. say
No,
it was
they
broken.
never
Say it was
said
broken.
there was. I mean,
They
it was.
said it was between his knees.
People said they saw it between his knees. They never said, "Here's the bottle of beer. We put it in an evidence bag."
True.
Well, there's a lot of these little details that would have made things a little more clear for us. I think if we would have, if it was a real trial and everything, and we would have seen all of the evidence.
all of
But the thing
Yeah, all
is,
these
we
little
have to
questions.
act. We have to act like if it's a real trial.
Well, yeah.
So
So if
I'm
there's no
thinking
evidence,
like
there's no evidence.
But there's no proof or
60-40
disproof.
toward Dana being at fault.
Okay. Ben?
Jack there made a good point about the beer bottle not being there. We actually don't have the beer cans either. We do have what looks like the bag of weed here, which makes me wonder. But that was never presented in the trial. But I do lean towards Dana being more at fault for the reasons said before. The fact that he went north on a southbound street, and like even if they are doing it safely in a truck that size that late at night, that should never be done. The fact that they, the lookout apparently failed to see anybody when it seems to be pretty well established that that Andy had his headlights on, and the fact, and like even the facts afterward, the fact that they apparently had a person on the job who was inebriated, who likewise gives a different testimony from the two people who
Well, it
apparently
shows
were
irresponsibility
sober.
also on his
And-
part as being the supervisor,
Yes, he was
allowing a
that's also makes me
coworker
wonder.
to drink.
He was the supervisor, and apparently, like, he may have been those two supervisors, but in a case like that, it seems like they should have had someone independently review the.
Normally they would.
Yes, and the fact that they didn't makes me very suspicious, and the fact that Mr. Bono's, he makes no comment on Mr. Bono's incident report, and no other third party took a look at those, and the fact that he does not seem to take responsibility in the case of Mr. Ward, who again was drinking on the job, and seems to try to use the fact he was drinking on the job to discredit what he says.
What proof do we have that Mr. Ward was drinking on the job?
He
That's
admitted
true,
it.
but
He said he saw him drinking.
that's
Saw him.
Dana's.
Dana said he did.
Right.
Dana's testimony.
But then it's,
That's true,
we have
so-
to believe him against Mr. Ward.
Right.
Yeah,
It's a sort of-
there's one word against the other.
It's a sort of catch-22. He looks bad either way.
Right.
But yeah, I do believe that Andy was likely impaired to some extent. I don't believe that he would have been impaired to the extent that he wouldn't have made zero attempts to, given how lucid he was in the text right before the accident, like right before he apparently could barely even type. But at that point, it seemed he was just lucid enough that if he was able to either step on the brakes or swerve, I think he really would have at that point. So I do believe that at that point, that Dana had pulled out in such a way that Andy had little to no time to actually react.
He was distracted by texting.
Right.
Okay.
See, that was one of the things I was kind
Possibility, but
of confused
so
on, was
apparently-
that last text that he had sent, because at one point I thought it was after the accident.
Yeah, no way.
But then they kind of were talking
No
about it
way
was
around.
before, so it was just like, I was trying to figure out timing and stuff.
If you
But
said
if you looked at
that-
some of the texting, when it was garbled, then the last texting, it was all clean and clear, and there was no, wrong words or anything like that. So,
So I think even if he was impaired, I think he still was loose enough that he'd have been able to react if he was capable of doing so.
What did that second mechanical engineer say? He didn't use the word impaired. Oh, inattentive. He said inattentive driver.
Yeah, he obviously did not see the truck. There's no doubt about that. He
For
slapped
whatever
right into
reason,
that
for
thing.
whatever reason, we don't
Yeah,
know.
for whatever
Yeah.
reason.
Well, and I want to point out with marijuana, and you can kind of just make a pipe out of anything. A beer can would be one thing. So, I mean, they didn't say what the beer can, he could have thrown it out into the graveyard for all we know. I mean, he could have.
well, he would have
been
thrown a
high.
lighter out the window also
Right,
for that
exactly.
matter.
Or, the little.
You can't use a cigarette lighter on a beer can.
You could, but I've seen it done. That's what I'm saying. So it's a possibility he could have been high off his butt. We don't know. That
Well,
at
okay,
all.
that was another point though, because at the
I
very
really
end
doubt
they said
that,
something about the
because-
pot, but being in a system, and that
Yeah.
never was brought up throughout the trial,
Right.
except for in that very last closing statement.
Yes.
I
You
mean, so
can't use
you can't
anything
really-
said in a closing
Yes, that's what I'm
statement.
just saying, is you don't know whether he was or
Right,
not. Or,
exactly.
But
Well,
they
But
did blood
it is
tests, so
true,
we might
there's
show up
nothing
in a
here
blood test.
indicating.
Well, yeah,
that was
but
the
listed.
if
sample
Emily
was
was searching for
contaminated.
it,
So since the sample was
Yeah.
contaminated, as a chemist, if a sample's contaminated, I can throw it in the garbage because no
Can't
results.
trust it.
Well, then for that matter, the
They
drinking,
say
the
Yeah,
blood
yeah.
alcohol
There
content.
was nothing
That's the only
nothing
circumstance
else,
I'm
right?
smelling.
No, it could have been 27.
Or it
would've
could have been
smelled.
nothing.
So,
Yes.
Ben, are you saying 100% for Dana,
I'm gonna say
60,
80-20 Dana.
80-20? Okay. Sue,
Okay, I flip back and forth. I think I'm more in favor now of Dana being more at fault. I don't know. Andy, had lots of issues, and I'm sure he was either drunk or high, one or the other. But to me, the evidence points more toward the trucking, and I do think they planted evidence.
What about Lisa?
What about Lisa?
All her testimony was bogus. And when they brought up the thing about financial, that made sense later, because her testimony was bogus. If she was so inseparable from her husband, were glued
Right.
together, how come you don't know what he makes? How come you don't know your finances?
Yeah, she doesn't.
And she doesn't know.
that doesn't surprise me.
No.
I mean, you'd think that'd be the case, but Andy signed a thing as the minister of the harvest or the hayfield, or that he supports daily use, or strongly supports and encourages daily use of marijuana. It's just circumstantial, but
Well, I'm
he's
not
right.
saying that. I'm just saying, you take a look at Lisa. You tell me she never writes a check. She never goes to the grocery store. She doesn't ever know their bank account balance.
My
Well,
daughter-in-law
that never
doesn't.
really came up.
My daughter-in-law
Yeah,
doesn't.
My husband doesn't know our background.
Most people do, though. And if you're inseparable, my husband and I were inseparable. I knew where he was all the time. I knew what he was doing. I knew how much money he was making. He knew how much money I was making.
Yeah, but I think people.
They were only together not even a year, so
Yeah.
and
Well,
even
she said
if-
you knew him 2 years, I thought.
well,
they were
lived
only
together.
married.
They lived
Well,
together.
They lived together for 15 months and
So
knew
who knows,
each other
even
2
if they
years.
had a joint account,
Yeah.
they
So
could have
But you
easily still
could
had
be
separate accounts.
you could be inseparable and still not discuss finances.
right,
And that, I mean,
people's
that-
versions of inseparable are
It was
different.
just-
And it just
Yours
depends
versus
on their
mine.
personal
He
beliefs.
We don't
didn't know.
quite
She
know
didn't
what their
know a
financial
lot of
situation
things.
is.
The other thing, she's going down the road at 70 miles an hour. We all drive 70 on the interstate, right? I mean, even if it's 65, we go 65. But we all go on the interstate, and we know what high speed is on an interstate. You know, when you look over to take a look at the cows, the farmhouse, or whatever, you have no more than a glance, and you're past it. And here she's going, I saw the truck lights. Well, she saw the truck lights. Why didn't Andy? She saw the accident. How could you see the accident when you have this much
As you're
time?
going up on something, you see it from this angle all the way past that angle.
Right.
And I drive with my window down all the time, and I don't necessarily hear noises. I mean, I wouldn't have heard beeping if I was on the
That's
other
true.
side
Well,
of the
'cause the
road.
wind is,
wind and
too
everything,
far
and
away.
But the thing,
yeah.
all
The
I'm
thing
saying
that-
is there wasn't enough time, because if you go by the engineers saying how many feet they travel by so much, she would have been well by that accident before it occurred, or she would have been back so far.
What you've done with what you were.
I'll confess that even though I lean towards
there's-
Dana,
let's
I
take
just
it back.
don't
There's
do
just
much
a lot
for,
of things that, yeah.
I'd like to
very
hear
seriously because
the
that
rest
was
of-
obviously very
Since you got to interrupt.
emotional thing, especially like towards the end where she talked about him getting up and saying that. I don't believe that happened. I think at that point she was hysterical. So
Right.
Right.
yeah,
Well, the
that's-
time difference also. She said it took 15,
Yeah,
20 minutes.
and
But
he
the police
died
got
within-
there within 5 minutes, and she was there before the police. So I feel like her time
It is very-
kind
it's
of.
very
She
confusing.
said that Andy talked to her,
Yeah,
but the
she-
doctor said he was
dead.
done
He
in
was dead
2 or
within
3
2
minutes.
minutes.
So
Dead people don't talk.
As a nurse, I can
mean,
tell you,
I could-
they tell a cancer patient, you've got 2 months to live, and they'll live
Right.
3 years.
My mom died in 2 days after they told her she had 2 months to live. So
Yeah.
yeah, there's.
Yeah. They're just going by guesstimates, so.
It was back to
And I
Sure,
think
what's
there's
the
a big
best
difference.
She was
situation,
talking
which is-
to these.
Well, didn't she
people
just
that were
walk up
there,
on
and
that?
Why didn't she? Yeah. Why didn't she just go straight to her?
Yeah, I don't think she actually had a conversation with him. I think she was walking to him
Okay, and
and,
they were
overheard them saying these things as she was trying to get to him. That's how I took it.
She fainted because she said she remembered
Well,
smelling.
smelling
Right.
salts.
Well, yeah, after all that kind of happened, she said she kind of blacked out. You know,
It's obvious it was a pretty traumatic situation for
right.
her.
I don't
She
really
said
take
she-
her
Did
her
she pass out after
testimony
she
into
talked to
account.
him, though?
Yeah, because
Okay,
she said
so
everything else
she-
and everything kind of got overwhelming, and she just kind of
Okay.
blacked out. But I don't really see a lot of fact in what she had to say, except for seeing the, being there, seeing the direction of the truck. I mean, I think that's accountable for something. She saw which direction it was going. The rest of her testimony, I mean, I know it's a sad, unfortunate, and probably cold telling, but I'm not basing my opinion off of her and her child and what it's going to do for her.
Yeah.
I'm just basing it off of, my facts of the time of the actual, collision.
Yeah, because hers is more emotional.
Right.
I think.
Yeah.
Yeah.
And when you face something that traumatic, you kind of see things in your mind that may not have
Right.
actually been true.
When you're waiting on a train and you're
Exactly.
panicking, I mean, you're not
Yeah.
going
She
to
wasn't
automatically
panicky,
turn.
though.
She-
Oh,
I
I
mean,
think she
she
She kind
was.
of
I
started
think,
visualizing
This is
what
sort of
happened
like-
in her head.
Yeah,
Calm
you-
panic.
everything's
It's
going
kind
on.
of
You know.
where, like in your head, you're going nuts, but your body
Yeah.
is just like
The first thing, I mean,
automatic transmission.
you're going to try to. I mean, you're not thinking clearly.
No,
Yeah.
no, not at all. Yeah, so.
Sue, do you have a
The only other
Sorry.
concern, the only other concern is if they were having money problems, maybe this was. I'm just going to throw this
Oh,
out.
it totally
Maybe
could've been.
this was
Yeah.
something that they planned together.
But did he
And
mean
it
to
turned out
die,
worse.
though?
And it turned
Well,
out
but-
worse
Maybe,
than what he
maybe he
thought.
didn't mean to
I
die.
know, yeah, I
Very
mean, I would
unlikely.
think if it were
Huh?
That strikes
planned,
me as
he
very
would.
unlikely.
You think that's
die.
unlikely?
Very
Yeah.
unlikely.
Why?
There's
If it were
two-
planned, would you go to a cemetery
Well,
where
why would
there's
you-
a secondary road where you're not going to have, I mean,
He wouldn't have known that truck
who
was
would
going
have
to be
thought
there.
that you
Well,
Yeah.
Why would they
What's
have had
he
those
doing?
texting
Unless-
conversations?
Unless they
Yeah.
called in
yeah?
Yeah.
to have them come check out the blown.
you think it was that well
Well,
planned?
you would have
No,
found
it, but it could have
Probably
been.
telephone records. I mean, yeah.
I don't know.
We're starting to hypothetical.
Can't do
Just
that.
looking at all the
But the question is,
So I'll go back to it's more the fault of the truck people.
I'm still in with you. I think, according to the laws of physics, he hit straight on, I mean, by the picture, he hit straight on
That,
to the
that
center.
bothers me a lot.
I
Okay.
envision he just pulled out real quick and was out there, and he just kind of came
Yeah.
in.
But he would have
Yeah.
been, like the engineer said, he would have been at an angle, and a car
and
going
so it should've
this
hit
way
from
would
the side.
have
Yeah,
hit the
no,
car.
Right, I feel like he got all the
That's
way
very-
out.
Yeah.
Well,
So he
he
had
was-
to have.
I
he
feel
had-
like there was more time
yeah,
where
it
if he
had-
would have been paying attention, he would have saw it and he would have avoided
Right.
it. I think he was texting or whatever, not paying attention to the road. I think they got out because he was in a hurry
Yeah.
and just was going fast and erratic. And
He didn't look good enough and just
Right.
ran
Yeah,
up and took
exactly.
off.
Well, and the other thing is, the expert witness,
Bless you.
witness for the defense said the truck could have been standing still, going forward or backing up. So let's say they pull out, the truck is standing still, and they take a minute to discuss something. You don't know whether their lights are blinking
And
because
boom, he's
They'll be,
there.
you don't
they'll be
see
on,
that.
because if the truck is on, the lights are on.
Well, he could
But
have
if,
been
but if
standing
he's not
still.
paying attention, then
Yeah.
boom, it hits anyway. Yeah.
Yeah, I mean, if he's not paying attention, it's gonna hit anyway. See, I ran a bucket pool. I know what it's like to sit in the bucket of a truck. You don't have vision like you do in a car. You're like this. You have blocked vision. And
that's-
so, even if you look, you can't necessarily see because there's something in your way.
the truck I drive for work, I have to rely on my mirrors solely.
Yeah.
And it is a pain. I mean, you can't always see.
I mean, I understand.
people come up out of nowhere.
Right. And they could have had one person get out of the truck and look and tell them if they're okay to back out.
Exactly.
But yeah,
I feel like it was very just erratic. He was jumping. He just
yeah.
was freaked out.
I'm not
Okay,
saying
Sue.
he wasn't freaked out, I just don't think he was that,
Sue,
I don't think-
percentage, or are you 100% Dana's fault?
Uh,
You mentioned there was
This is your
some
big
so
moment.
let's go
Let's
60-40.
60/40. Okay.
And what are your thoughts?
Yeah. Yeah.
Initially, I leaned more toward Andy when I looked at this, at all the evidence and stuff. And believe it or not, both with the closing argument of the plaintiff attorney, you know, we're not deciding guilt here. This is not a criminal thing. We're not trying to decide guilt. In a criminal case, we're just trying to decide, you know, what does the burden of proof show? No one's going to jail here. No one's getting hurt. The insurance company that insures the truck company has plenty of money, I guarantee it. Am I trying, even if I felt Andy was not only inattentive, but totally distracted and impaired, we still have a case, and here it says instruction 11, comparative fault, single plaintiff essentials for recovery. The plaintiff claims the defendant was at fault in one or more of the following particulars. The defendant's employees were operating the truck in a negligent manner, especially in one or more of the following ways. And then a third one here says defendant's employees failed to yield the right of way to the vehicle being driven by Mr. Little. Okay.
Absolute.
I don't know that that's
I
true
feel like it
because
is.
we're assuming that they're backing. If they weren't
No,
backing,
even if they weren't,
Yeah.
even if they weren't backing,
if they were sitting on the road stopped and he ran into the back
that's
of it.
negligent.
But he had the right of way
He had-
still.
Yes.
No, not if
No.
I'm sitting.
If he's sitting still, it still was his responsibility.
You shouldn't be
say-
sitting still on
That's right.
a road that, unless you're parked and it wasn't a parking
Yeah,
place.
not in the middle of the road,
But
yeah.
you
And
could
usually
be
you put out the like little, you know, the cones and stuff, you
There
know.
was a storm the other day. I'm driving home from work, and there's a utility truck with its lights on sitting in the middle of Army Post Road. They don't have any cones on. Out. They don't have any people out. They're just sitting there. If I would have hit their tail end, who would have been responsible?
They would have been.
Probably you.
You.
Yeah.
Me. Because
Came from
in
the
Iowa
rear.
law, if you hit somebody from the back end, it's your fault.
But why would, but your expectation would not be that a truck is stopped in the middle
Right.
on the road.
If someone is in
Doesn't
their
matter.
driveway and they back straight out into a street and you hit them,
Yeah.
that is not your fault.
No.
I mean,
But if that truck's sitting in the middle of Army Post, if I drove up and hit it, it's my fault because
We should
according
have
to
paid more
Iowa
attention.
law,
You hit it from the rear.
should have been more
Yeah.
attentive.
if you hit somebody from the rear, according to Iowa law, it's your
That's
fault.
true.
Anyways, let's
But
kind of
this
move
is
on with
illegal.
his.
This is an illegal
Well, okay,
case.
so in order to prove this claim, the plaintiff must prove all of the following propositions. One, the defendant was at fault. In order to prove fault, the plaintiff must prove A, defendant's employees operated the truck so that it was facing south, but defendant's employee, big A, was operating the truck in reverse at a high rate of speed. They have to prove that. B, they have to prove defendant's employees also failed to keep a proper lookout.
Now, that's
Okay, we probably
I
should
mean, that's
take one
proof
by
because
one.
obviously they got hit.
They
They
got
didn't
three
see.
They
guys.
haven't really
Yeah.
proved those.
Yeah, they haven't proved high rate of speed.
Defendant's employees, and C,
No, the first one they didn't prove. The
They
second
didn't
one
prove,
they
so
did.
we have to do them all, don't we?
No,
Just
Yeah.
one, wasn't
Oh,
it?
I thought
well,
it said
well,
all.
no, my fault. It says the defendant's employees were, okay, well, let's see, where was I? The plaintiff claims the defendant was at fault in one or more of the following particulars.
Okay.
Okay, so the plaintiff's claiming that. It says in order to prove this claim, the plaintiff must prove all of the following propositions. The defendant's employees operated the truck so that it was facing south, but defendant's employee was operating the truck in reverse at a high rate of speed. They have to prove that he was going backwards at a high rate of speed.
They never proved
And they
that.
They
proved,
did,
didn't prove
yeah.
that.
So we can't.
B, defendant's employees also failed to keep a proper lookout. Well, there was no videotape. I mean, there's
No, we
nobody
don't know
knows,
that.
right?
Yeah.
C, defendant's employees failed to yield the right of way to the vehicle being driven by Mr. Little. Or D, defendant negligently entrusted the operation of its truck to Mr. Little.
They didn't
And like you
prove that
said, there
either.
was no, the company never did cite or say
Say he had to go to a
that
therapist.
Dana was impaired or should not have been driving because of his mental condition.
So they didn't prove 3 out of the 4 of those.
The one that didn't have the
Yeah,
proper
that didn't
lookout,
do
isn't
one.
that proof that, I mean, they got hit, they got in an accident,
No, that doesn't
No.
prove anything.
Well, it just proves that they didn't see someone coming.
What doesn't prove
No,
anything? How
that
does that
doesn't prove that. You
prove?
could have pulled out and saw somebody.
Yeah.
If they have to prove all of those, then the plaintiff did not prove their case.
Right. Even if they got 3 out of the 4.
Exactly.
That doesn't seem fair.
Well, we're not
Well,
here
it's
for fair.
different. Civil.
Defendant's fault was a cause of the plaintiff's damage. Well,
I'd like to hear a clarification of that from somebody. They really have to prove that all 4 of those happened?
Yes.
Yeah.
If you
can
contend
read.
that, you have to.
Will you read it one more time?
okay, in order to prove this claim, the plaintiff must prove all of the following propositions. One, there's 2 propositions, and part 1 has 4 parts, A, B, C, and D. One is the defendant was at fault. In order to prove fault, the plaintiff must prove A, the descendant's employees, or the Big A's employee, Mr. Miller, operated the truck so that it was facing south, but defendant's employee was operating the truck in reverse at a high rate of speed. They have to prove.
Yeah, the high
prove
rate of
that.
speed
prove
is a
that.
You
problem.
didn't prove that.
B, the defendant's employees also failed to keep a proper lookout.
And we don't know that. They
They
didn't
don't.
really
They
prove
didn't
that.
prove that. They didn't
No.
show that.
And it says must prove
No, I
all of
think
the
they
following.
did.
And this is all part of the first thing, number 1. But C, defendant's employees failed to yield the right of way to the vehicle being driven by Mr. Little. Or D, dependent negligently entrusted the operation of its truck to Mr. Miller.
You know that's not true.
So that means
Well, we
And
don't
then
know.
the number 2 that they have to prove, I mean, that's 1 with 4 parts. And then number 2 is the defendant's fault was a cause of the plaintiff's damage. The defendant's fault was a cause of the plaintiff's damage. If the plaintiff has failed to prove any of these propositions, the plaintiff is not entitled to damages.
well, then that means that
If the,
Andy
pla-
does
if the
not.
plaintiff has proved all of these propositions,
All.
prove them, all of them, you will consider the defense of comparative fault as explained in instruction number 12. You would reread that?
No, I think
No, what did they have to?
Nobody
What did they
proved
have
high
to
rate of
prove?
They didn't prove that.
What was the second one that they had to prove?
The defendant's fault was a cause of the plaintiff's damage. I'm guessing that means the defendant was at fault and caused the plaintiff's damage.
But if they didn't
So basically,
prove the
if
first
that's
one,
proven,
how
it's
could
their
they
fault, then Andy died.
claim the second? Because they didn't prove the fault in the first, so how can they claim damage in the second half?
Well,
Well,
the
yeah, they have to
second
prove
one,
the fault, and that the fault of the accident was the reason that he
That
died.
they got damaged, that they need damages.
So
Yeah.
therefore, they've lost the case.
the second one doesn't matter if you can't prove the first.
And
So,
they didn't prove the first.
No.
well, there we go.
Yeah.
The
I
burden.
don't like that outcome.
Well, you know, you can't be with your emotions. Yes, I wish
Not
we
doing
could
it
write a
with emotions.
2,000 million check to the poor lady with the
I'm not
baby.
doing it with emotions. I feel I have some really good reasons why I was leaning toward the.
Right. I feel like he admitted that he was erratic and he was kind of freaked out. And the text message even to his therapist at the very end. The little pieces that they left out,
That
they had
was in
everything.
closing. You can't use
I know,
what's
I'm
said
just
in
saying.
closing.
But
We
I'm
know
basing
that.
it basically off of all the things that were.
Prior to closing.
Yeah.
So you can't use what he wrote to the doctor because that wasn't introduced until
Okay,
closing.
strike that I said that. But
50 lashes, Tom.
yeah,
First thing the judge told us in the morning. That's why I
Oh my
marked
God, can we
everything
just finish this up?
closing and
Yeah. So they didn't prove that, are we done?
I mean, if that's a simple, again, we're not saying who's at fault.
No.
We're just trying to
We're
do
looking
the
at the
best with it.
evidence.
we're just saying that the plaintiff didn't prove their
Didn't prove
case.
the case.
Because they didn't have the evidence to prove it.
Yeah, they didn't have the preponderance of evidence.
There you go.
Are you all good with that?
Yeah.
yep.
With those
Not good
guidelines,
with it,
yeah.
but what are we gonna do?
Yeah, you can't prove anything. Now, if it was 2 people out on a highway and it was you know, one word against the other, you have no proof either.
Right.
I mean,
Yeah.
I like the way these lawyers tried to throw in red herrings, because when the plaintiff was interviewing the defense's witness, he said, well, Dr. B is a biochemist. What's that got to do with the price of tea in China? Did you know that he was a biochemist? What's that got to do with the price of tea in China? I don't care. And the other thing, you know, nobody ever picked up on the fact, why was the power company's expert not charging money? He charges $3.35 an hour for consultation.
right, I thought they were
But
going to
he-
go somewhere with that. Why?
I did
didn't
too,
ask
but he
why
said
Charge them, yeah.
Right.
Yeah, but didn't go anywhere. I'm
That would be
donating my
wrong.
services. Well, maybe he does donate services. Maybe
Okay,
it's
so let me
just pro
read you the
bono.
jury verdict form here.
All
Verdict
right,
number one.
members of the jury, there's some people that want to thank you for your hard work.
Oh, yeah, that's
We were a good jury.
Thank you
Okay.
so much for coming in.
I guess we'll just have to say that we didn't prove their case.
We were a regular jury.
Well, I don't think we can prove that he was going at a high rate of speed.
I think at this point,
This won't take long.
That's the thing that's bad. You were that thing, representative of a jury. You walked off.
well,